Assalamualaikum. Today our group is want to present about estate planning. Okay, what is estate planning? Estate planning is the process of developing a plan to administer and distribute your assets after deaths in a manner that is consistent with your wishes and the needs of your survivors while minimizing taxes. It means when you are dead, you have to distribute your property to your wife, your children, so they know their rights on your assets. Then we move to the next slide. Will. What is will? Will is a written and a legally enforceable document expressing how a person's property should be distributed on his or her debts. It means when when you create a plan, you have to write on a legal document as a proof. So your wife, your children trust the lawyer that you are the person you are the person who have right right that okay. Then we move to the next slide. What will happen when we don't write a will? It's called intestacy. Intestacy is a situation when a person dies without a valid will. Okay, then we move to the how to preparing the will. What is the requirement? Okay, first we have to know what is testator. Testator is a person who makes a will that provides for the disposition of property at his or her deaths. It means you the person who writes the will. Okay. Then okay, firstly, the first step how to preparing the will is provide a plan for distributing the status assets according to his or her wishes, the beneficiary's needs and tax requirement. The second step is consider the changes in family circumstances that might occur after its execution. Okay, the last step is concise and complete in describing the testator's desire. Okay, that's all from me. Thank you very much.
Assalamualaikum. My name is Abid Arif. I'm going to explain a little bit topic about faraid. Obviously, we must know the definition of faraid first. What is faraid? Faraid, or law of inheritance in Islam, which also known as ilmu faraid. It is basically a section of the Islamic law that deals with the distribution of the estate for a deceased person among his heirs, in accordance from Holy Quran and Hadith. Next is about order of sequence of right on the estate. It means when a person dies, those living such as the family of the deceased must following the order of sequence of right on the estate. Okay, firstly, to discharge all the obligation such as relating to zakat, various kafarah or penalties for oath, zihar, caution while fasting in the month of Ramadan. The second one is to pay his funeral expenses. And the third one is to settle all his debt to his fellow beings. The settlement of such debts shall include the performance of the Hajj or on his behalf if he had not already done in his life, and the payment of mahar if payment had not already been made. The fourth one is to execute his will. A will is not for a person's heirs. The amount of estate provided for in a will for disposal shall not exceed 1/3 of the remaining estate after the settlement of the step number 1 to the number 3 previous. And last one is to distribute the remaining estate among his heirs after the settlement, all the previous steps that I have already explained. After that, we go to the type of estate. This is briefly to explain the type of estate. Estate is all the assets and liabilities of a deceased person which, according to Islamic law, that may be inherited to the heirs. There are several least types of estate which I will explain one by one. The first one is immovable property. Immovable property such as a building, piece of land, or a plantation. The second one is movable property such as money, shares, jewelry, equipment, vehicles, and clothes. The third one is money owed to a deceased person. The fourth one is a property that has been mortgaged or pawned by a deceased person and that is redeemable. The fifth one is a property purchased by a deceased person during his lifetime for which payment has been made by him, but the property has not been delivered to him until his death. Next is mahar or dowry that has yet to be paid to a wife until the wife's death. Other than that, other assets such as savings, EPF money, shares, unit trusts, bonds, and insurance policies that are approved by Islamic law. After that, all the aforesaid property in and outside the residence of a deceased person. And lastly, all other assets of material value. Lastly, is about the causes of inheritance under Faraid. How does inheritance under Faraid happens according Islamic law? The first one is by nikah or by a valid marriage contract in Islam. The second one is wala or relationship. Relationship or bondage where the cost for the inheritance of the emancipator to the estate of the emancipated slave is the benefit of the emancipator over the emancipated person. Through this, the emancipator becomes entitled to inherit from the estate of the slave whom he emancipated, irrespective of whether the emancipator is a male or female. And the third one is nasab or kinship. It means relationship through womb or blood. Through this kinship, the parents and whosoever is related with them, and the children and whosoever is related with them will inherit.
Assalamualaikum, my name is KARLIF and I will talk about entitlement in Faraid and the issues in Faraid. So in the family, for every entitlement, they are different. So for the first one is the husband. If the husband doesn't have a son or grandchildren from the son, the husband will get one of the two. And if they had sons, the husband will get only one of the four. As for the wife, if the family had no son, then she will get 1/4. And if they have a son or grandchild, the wife will get 1/8. As for the father, if they have a son or grandson from their own son, the grandfather will get only 1/6. And if they had a daughter, he will get 1/6 also. For the next is the son. If he is the only son and no daughter, he will get 1/2. And for the daughter, if they the family has only one son or no son, the daughter will get 1/2. And if the family had two or more sons, the daughter will get 2/3. For the mother, if they had one son or son, grandchild, or siblings or uncle, the mother will get 1/3. If the family had none of the above, she will also get 1/3. As next for the issues related to faraid. As a Muslim, it is only allowed to give 1/3 of the estate in a will. If more than 1/3, the person must get the consent from the deceased heirs. If without consent, the heirs can only be entitled for 1/3. The first one is hibah. A Muslim can hibah his estate to anybody within living duration, whether partial or all the assets, for example, by transferring the name in the house, title, car, or land. Assets which can be placed under the hibah trust consist of movable assets and immovable assets with value. These assets must exist during the contract. Example of movable assets is cash, bank savings, and shares. Examples of immovable assets such as buildings, houses, and lands. In Islamic laws, hibah is valid once there is ijab and kabul about the gift that she wants to give away without consideration. It is haram to ask for the hibah back even among siblings. Husband and wife accept a hibah from a father to his son. That's it for the hibah. And next is the nominee in insurance or EPF. In Islamic law, nomination of the above are considered not valid or does not fall to the nominee upon the death of the deceased. It is still contrary to the faraid. This is stated clearly by the Jawatan Kuasa Fatwa Kebangsaan 1973 in the Mesyuarat Majlis Raja-Raja on 20 September 1973. That's all for the issues related to faraid. So what do we learn about faraid? So an estate means money or property left by the deceased, and estate planning, process of disposing of an estate after one's death. So this estate planning is very important to every family so that there is no problem when dividing assets to each and everyone. So that's all for Faraid. Thank you.